So it's Friday night, you're President Trump, Friday evening, and you're the Trump legal team, and you get a letter from Judge Merchan, which you haven't received in a while yet. You know that you've got sentencing on July 11th, and that's likely when you'll file your motions to appeal and your motions to place a stay on any kind of sentencing. But this letter is kind of take you off guard at first because it's dated June 7th. And it was via email to both President Trump's attorney and the assistant district attorney, so someone who would work with Alvin Bragg. And it said, "Dear counsel, today the court became aware of a comment that was posted on the Unified Court System's public Facebook page, in which I now bring to your attention. In the comment, the user, Michael Anderson, states, 'My cousin is a juror,' and says Trump is getting convicted. Thank you, folks, for all your hard work." Now, here's what's interesting about the comment. That was 2 days into the jury deliberation, 1 day before they announced their verdict, that you have that comment. You also, the comment was under a part of the 4th Department of the Appellate Division's Facebook page. So it was not on the trial court's Facebook page, and it was under a post that was unrelated to the Trump proceeding at all. It had nothing to do with that. And this is all coming from the official letter from the judge. This isn't like the Trump team. I want to make that clear. Internet sleuths didn't find this. Fox News did not find this. Newsmax didn't find it. The Trump legal team didn't find it. It was the courts, and it was the appellate court division that found it and made notice to the trial court judge. Now, here's what's important. Because unlike most social media posts, this has brought up kind of a can of worms that I'm not sure. I think the media tried to dismiss too early. And I want to go to Harry Hutchinson on this because, Harry, the media tried to dismiss this as this is likely a hoax. It's likely this, it's this person on the internet that's trying to, start something and, and this is what they do. And look at their profile. That's, of course, even if that name is right. But if you want to take it seriously, and it looks like they are by putting it on official letterhead and notifying both parties on Friday evening last week, that you need, as the court, to call in those jurors, have them put under oath, and ask them just a series of basic questions. And I don't even think the key question is the Michael Anderson part, or even, is this your first cousin? I think the first question is, during jury deliberations, did you make any phone calls to family members that indicated how the jury was going to decide and announce their verdict the next day? Because if they did that alone under oath would lead to the potential for a mistrial. And what if you had 2 or 3 jurors raise your hands? Then this could open up a can of worms that's much worse than just this Facebook post.
Absolutely. And so the other corollary question is whether or not the jurors had any conversations with individuals who were not part of the jury pool. Right. And based on this particular post, one could certainly infer that communications did in fact occur. And so I think the court has the power to compel the jurors to testify, and they need to get to the bottom of it, and they need to do so very, very quickly. And so we need to adjudicate first when the post was made, whether the poster is indeed a cousin or relative or outsider, with respect to any of the jurors, because keep in mind, in theory at least, the names of the 12 jurors and the alternates were kept private throughout the Trump trial. And so I think the calls made by many Republicans for a mistrial are indeed appropriate in the sense that they are bringing appropriate pressure to bear on the court to act and act expeditiously, in part because the sentencing for Donald Trump is to take place within about a month.
Yeah, I mean, I look at this, Will, and I go, to me, once you've had time to digest it and you think, this should open up that can of worms. And listen, you could open up that can and all those jurors could be under oath. They say, nope, I didn't do that, And then I'm not sure what else you could do other than some maybe internet research, maybe trying to tie this metadata, something like that. But the first thing you do is say, it's not even about Michael Anderson. It's this is a public story now. It's putting you under oath. It's saying, did you have conversations with people that shouldn't have been privy to those conversations, that we told you not to do, that could have also told someone like this? I mean, think about that. If you were speaking to someone in your family, and then that person decided, let's play phone tag, I'm going to call someone else and say, I've got some cool information from you that my cousin, friend, coworker, a husband, wife on the jury said that we're going to get a guilty verdict pretty soon in this case, and Donald Trump's going down.
Well, and I think that's been the problem.
About the Facebook post,
right?
There's grounds for a mistrial there.
Once again, this is not a letter that the judge wanted to send, right? And we got it Friday evening, so perfect timing to hopefully get lost in the shuffle of the news cycle going into a weekend. People aren't paying as much attention, but I think it also highlights what has been the problem many commentators and legal analysts have seen with this entire case, is that it was based on an underlying crime we didn't know. There was a novel legal theory presented to get these to be highlighted and raised to felonies against the former president. And then even some of the oddities of allowing, we're going to have a short day here so this juror can go to a dental appointment. The jury wasn't sequestered in this very, very high profile case. So the judge, while I don't believe he wanted to send this, also allowed for this in some way to happen by not sequestering the jury, by not having heightened protections against something like this when you know that this is a high-profile case. It's what people that have been critical of it have been saying from the beginning. How is he going to get a fair trial? And now you have a letter that we can't look at and just dismiss out of hand of like, oh, how many people on the internet said, of course he's going to be guilty, but that the judge had to take seriously, had to bring before. And as you see, this could potentially get short-circuited before it even gets to the appeal. But that's a question I have for you as well. Even if this, say, doesn't pan out to be a legitimate poster, they can't determine it one way or the other, and so mistrial doesn't happen. I don't think that's off the table, but it potentially could be off the table coming forward. Do you think this gives the Trump defense another avenue on the appeal of, look at just how chaotic this entire process was? It wasn't run fairly and deprived me of basic rights here.
Yeah, I think absolutely. I think that, listen, when you go on appeal and you start looking at, getting Friday night letters after the juries come back with their verdict about a post made while they were deliberating, and that's coming from the judge with information that came from the appellate division, you, of course, are going to include that somehow in your appeal. But before you get there, and I think you want to, I don't exactly know what you'd file, but I think you want to file something with the court that makes sure that the court is doing its due diligence. Really, the Trump campaign cannot put those jurors under oath again. They can't contact them. It's only the court. Alvin Bragg can't even do that in his team. So it's really the court now has this duty. And it's also important for the court. I mean, Harry, this is why it's important for the court to do it so that all of this, if it can be put to rest, is put to rest, because you go to, again, just are these just pre-cooked sentences against Donald Trump, and people have said that this is all cooked, that this is all again set up because we're doing them in Manhattan. We're putting two lawyers on the jury pool, and they come back in 2 days that we don't even know what the actual felony is, but we do know they're going to get convicted, as the person wrote on Facebook, and they're the ones that could put them under oath and say what happened here.
Absolutely. So whatever the outcome of this particular case, first, this post suggests the impossibility that Donald Trump could, in fact, get a fair trial in New York. That's number one. Number two, the judge failed to take appropriate safeguards, as Will indicates, with respect to protecting the jurors from outside influence. So that the jurors were not sequestered. Their cell phones, as I understand it, were not taken away. Their ability to communicate over the internet was not taken away. And then thirdly, the judge likely committed reversible error with respect to the jury instructions. Why? Because the judge failed to require that the jurors reach a unanimous verdict with respect to the underlying crime. And indeed, the underlying crime was not even specified in this particular case. So I think a lot of Americans believe that this particular trial was indeed unjust. And so it strengthens the argument at the end of the day for a mistrial.